that. Yeah, so my name is Rumbidzai Vunzawabaya, and I am a business owner as well. So our understanding of the sponsorship system comes from two different perspectives, from the compliance perspective as a solicitor, and also from the practical perspective of implementing the system and working with people and the different challenges that come. So it comes from two angles. Tulia is a community interest company. So we also have a lot of work that we do with your carers, with staff, with employers. This webinar today is for employers, but our work supports both people. So we give advice to your staff, we give advice to employers as well. And the work that we're doing with employers has increased over time, and more recently in the last few months, because of compliance issues and challenges that are there in the sector. So today we're having this webinar to just talk about some of the issues that are happening, to update people, but also to talk about a significant case that came that was ruled by the High Court, which is Prestwick Care Limited and others. And some of you may have seen it. This was one of the first recent cases that has gone to the High Court in recent months, which is dealing with the Home Office's decision to revoke a sponsor license. And there's a lot of issues that have come out in this case, which are issues that affect a lot of employers, sponsor license holders, or even people who are anticipating to have a sponsorship license. The judgment in Prestwick Care Limited and others is a very good but harsh reminder that the Home Office is hot on compliance, and sponsor license compliance is taken so seriously, and non-compliance can lead to such significant consequences for the employers and for the migrants and employees who are working for sponsors. And there's a lot of lessons to be learned for other sponsor license holders. But in addition to that, there is, on a day-to-day basis, there are practices that we are seeing in our job, that we are seeing that is happening, and there's a turn in that the Home Office is taking really strong action against sponsors, and they're taking action without even visiting sponsors or doing a compliance visit, but taking desktop audits, and they're taking action. So what I mean by that is the Home Office is looking at other agencies, so looking like at records from HMRC and records from CQC, from local authorities, and they're gathering intelligence as well as looking at information that is online and taking decisions to suspend sponsorship licenses, and then ask employers to produce evidence that they're not breaching the regulations, that they are genuine employers, that they're not a threat to immigration control, that they are not abusing the system. And the main reasons that this has happened is, one, there's been a large outcry about the immigration figures. So the numbers of immigrants who have come in has been so massive that the government had not anticipated that the numbers would increase by such a large amount. But in addition to that, there has been a lot of information that has been gathered from whistleblowing, from employees who are in the UK who have come in under the guise of the sponsorship system, that they're coming to work as a healthcare worker, but they find that there is no genuine job, or that there is no genuine vacancy. And that's left people destitute. It's left people ending up in social care, with children, homeless, and in need of support. We have seen a massive increase, absolutely phenomenal. Like, percentage wise, I'm not so good with the numbers, but the numbers have increased significantly, and we recorded and looked at it when we were doing our report for the end of last year. And the number of people who are homeless, who are destitute, who are here illegally now, who have come thinking that they're coming to work, or knowing that there's no job, because some people have been taking part in this, knowing that there's no job, but taking a risk and ending up on the street, ending up with children in social care, ending up being served with eviction notices from their accommodation. So the referrals that we're getting are coming from other charities, that deal with migrants, homeless charities, social services, and other organizations like Unseen, which deals with victims of modern day slavery and human trafficking. So all of this information is going around the sector. It feeds its way back to the Home Office. When someone turns up at social services, they've come as a carer, but they're saying there's no job, I can't look after myself and my children. Then referrals are made to the Home Office. So the reports are going around the different sectors, and the Home Office has now had to take action. And the action that they're taking is perhaps action which is, it's like trying to fix a problem, because the Home Office just issued out licenses, unlimited. People were able to apply 400, 500. They didn't do due diligence about the organizations, and they gave out certificates of sponsorship to people who were perhaps not genuine companies, people who were not um, who were not um, who were not genuine, who were not really seeking to employ people for work, but were seeking to bring in people to the United Kingdom for the purposes of migration. Um, and so the issue of genuine vacancies has triggered a lot because of the consequences. It's a ripple effect, isn't it? It's an effect on so many different aspects of government, NHS, everywhere. It's mental health services. It's a ripple effect, and as a result of that, the Home Office has changed their approach on compliance, and they're coming in quite heavy-handed, belatedly, I think, but it's never too late. The reason why it's important for them to take such action is because of the consequences of just allowing people to enter into the UK when they don't have a job, they don't have recourse to public funds, they don't have access to resources to help them, and that's causing a burden to the taxpayer and a burden all around. So it's to families, to relatives. The ripple effect is very, very serious. And so that is perhaps painting a picture of what is happening on a bigger scale. And the people who are affected are people from all over the world. People from Bangladesh, people from Nigeria, people from Zimbabwe, people from Kenya, people from Philippines, everywhere. There's people who have come in on this sponsorship system where it's like the Home Office has opened the doors of the United Kingdom, and now they're trying to clean up the problem. So the things perhaps to be aware of if you are a sponsor, I think this webinar today is geared at sponsors. I haven't done a particular slide for this particular webinar, but it's highlighting the issues. If you've got any experiences that you want to share in the chat, or if you've got any questions, please feel free to share them. and to pop them in the chat and to ask any questions as I go. So the issues perhaps to look out for if you are an employer, if you are a sponsor, in readiness for either a visit, or that if you know that perhaps you have recruited more people than you need, far more than your business can absorb. If you're struggling as well to pay the people, if you are a person who knows that perhaps you have too many, you've taken on too many people and you don't have a genuine vacancy, it's important to be able to, at this time, to assess and to know. I think we might take it for granted in terms of compliance that people will actually have a list of the people that they have sponsored, that an employer will know that I've sponsored 100 people, 10 have left, I have 90 who are going to work. But that may be an assumption, because not everyone knows. It may be that the record keeping is not good, the way that the business is operating. The business has grown from a business with 10 employees to a business with 100 employees in less than a year. That's something, again, that the Home Office is picked up on, and they're picking up on how businesses have grown so quickly. They're looking at evidence on Companies House, past accounts. They're looking at CQC reports. They're looking at how quickly has the company grown, how many people have they sponsored. Is this something which seems like an organic growth, or it's facilitating immigration, it's facilitating human trafficking, so trafficking people into the UK. So as a business, it's important to take stock of how many certificates of sponsorships you have issued ever since you were given your license. That should be something that comes at the tip of your fingers. It should be information that is available, information that doesn't have to be looked for. And the tracker should show how many people were issued visas, how many people have left and switched, how many people are still working for you, and are these people getting enough hours? This is something that is very basic, but that is the starting point that the Home Office takes. How many people have you sponsored? Where are they? And you'll be surprised that 50-60% of sponsors don't know the answer to that question, or they're unable to bring that information in a couple of hours, or to pull it up from their system. So the Home Office they're doing spot checks at different points, at points where a person is applying for a visa. They're checking with the sponsor. Do you have work for this person? Show us your rotas. Show us the people that are currently working for you. Show us your contracts. So we've seen them asking for information at the point of visa applications. We've seen them asking for information at the point of applying for more certificates of sponsorship, and just randomly. So they ask for that information and expect you to have it. So from that information, the Home Office will be able to read and understand and know whether or not, as an employer, you are a threat to immigration control, or you are complying and not abusing the system. So the numbers of people that you have, whether they're doing the adequate hours which are on their COS and being paid for it, is information that the Home Office will also be able to substantiate from the HMRC records. So they'll be able to easily see that information from your pay-as-you-earn records. So your pay-as-you-earn records should align with the people that you are sponsoring. So when you've sponsored someone, you write the PAYE reference for your company on the certificate of sponsorship. And that's the first part, that's the first place that the Home Office will look to say, So how many people do they still have? And how many people have left? Have they recorded this on the system? Are they getting paid enough according to what they should be getting paid on their certificate of sponsorship? So they will start to do their assessment based on the information that you give them, the names that you give them. They'll look at the sponsorship management system to see, have you reported that people have left? Have you reported where you've had to fire people? Have you dismissed people? Are they on maternity leave, sick leave? Have you notified and reported that to the Home Office? From there, they will then assess and see whether there has been a potential, where the breaches are. They'll ask you to explain. But the information that they already have is based on information that is readily available to them from different organizations. So for people who know that there are things that need to be tidied up, it's important to have an audit. It's important to have a mock audit where you do it in-house with your HR, you do it with an immigration advisor, something that we do, where we ask those simple questions. How many people do you have? Where are they? Where are they working? How much are they earning? From that, we're able then to go on and assess all the different things. Where is this person? Why are they not there? Etc., etc. So it's important to clean house, to understand where you are. The Home Office considers that sponsorship of foreign workers is a privilege, and it's not a right, and therefore, as a sponsor license holder, you are subject to a very high level of scrutiny, and to ensure that the system is not abused. And that vulnerable people who are desperate to live in the United Kingdom are also not abused. So those are the things, the key things that the Home Office look out for. And it's important for the common reasons that we've seen for suspension are not having a genuine vacancy, not reporting, not reporting changes in commencement dates. And that's something that we've seen that is very, very, very common. And a lot of some sponsors, they haven't read the guidance to understand that a person is supposed to, if once they issue their visa, they're supposed to start within 28 days of the day that their visa is issued, or within or on the start date, which is on the COS, but not within 3 months. So you'll find that people have misinterpreted and thought that the employees can come anytime, or that their employees can come into the UK and stay for months before they actually start work. So not reporting things like changes in commencement date, not reporting when a sponsored worker has left, not reporting changes in circumstances, not having genuine vacancies, and not paying people in accordance with the minimum wage and the minimum amount that they are supposed to be paid. Because if you have agreed with your staff that you will pay them a certain wage per annum, and they've made a decision to come to the UK and work for you on that basis, if you pay them less because you haven't been able to provide them with the employment, then the Home Office will calculate that as underpayment, because they calculate what you've paid them divided by the hours that they are supposed to work. And so they will view that as underpaying and not paying people in accordance with their contract. So those are other common issues that come across. And in the case that we were talking about, Prestwick Care, it's a care home, it's a big organization. They're the same issues, failing to report, not keeping records, not complying with the sponsor guidance, and not having genuine vacancies. So some of the vacancies they had were for the different job roles. So senior care assistants instead of just normal care assistants. So people who are carrying out the role for which they're not being sponsored. So those are some of the issues that came across, where the salary is different, where people have been promoted, but their actual visa hasn't changed. So you can find somebody is a coordinator of the service, a care coordinator, deputy manager. They've got a new contract, new salary, but the employer has not changed their COS and updated their visa and given them a new visa. That's another common reason, which is a breach. Another common one is not complying with UK employment law in relation to sick pay. So there are many breaches. So when someone is off sick and they're not being paid sick pay, or being told that no sick pay is available for their role. This was one issue that was picked up in the Prestwick case, but also I've seen that issue being picked up with many suspension letters as well, and leading to revocation, because non-compliance with UK employment law will normally result in sponsor license revocation. And so these are issues that are important to understand and to ensure that you are compliant. So I'm just going to jump on to some questions. Yeah, there's some questions here. Wow, thank you. So I know there's some people, we've got a maximum of 100 on the call now. It's just our Zoom has a maximum of 100, unfortunately. So we are not able to, I know there's some people who wanted to join, but we will share the recording and share that with everyone. So yeah, okay. So I was just going to answer some of the questions which are in the chat. I'll start with the one that says, what if you're doing everything correctly and carers are using you as a provider to enter the country, and then you have a huge exodus, say 10 to 18, but they had hours and shifts in abundance? So thank you for that question. As long as you are doing everything correctly, you have proof that you've got the hours, because and you've been paying them. If they leave for whatever reason, they have got a job in the NHS, or because the NHS is recruiting locally, because you've trained the people, they've acclimatized, they're easier for them to take. And I know companies like LSCM, big organizations, are recruiting people who are here. And so if you are doing everything by the book, what you're supposed to be doing, you have proof of that. If the Home Office asks you questions, why did you have a mass exodus, 10 to 18 people, but you've notified, you've updated the Home Office, your sponsorship management system, you've updated it, you've been paying them their salaries, you have evidence that you've got enough hours and you've got shifts work for your staff, then you have nothing to be afraid of when people leave. If people want to leave, let them go. As long as it's a big investment for your company in terms of you've trained those people, you've got them to a place where you have stability, and then people leave. It's very frustrating, but it's one of the things that happens. It's one of the risks that you take, and unfortunately, there isn't much that you can do about it. But you will not be penalized if you can prove. So it's important to keep a record of everything. Even for those workers who have left, you still have a duty to keep their records. So people leaving, they will leave, and that's fine, but you have to show that you were complying with everything and you've done everything by the book. But where you have people who are an employer who is constantly getting people who come in and leave, come in and leave, come in and leave, come in and leave, because what their main business is not the care that they are providing. It's the facilitation of human beings from one country to another, which is called also human trafficking. So that can be a flag to the Home Office for somebody who has found a business model of trafficking people. And so large amounts of people leaving or you taking people off will cause the Home Office to think, why? And if you don't have then proof to back it up that you had the hours, if your company accounts don't show that in the next year or the year after that you had 400 people working for you, you should be making quite a lot of money. If your bank accounts don't show, if you don't have the contracts to back up that you've got the work for these people, then that will cause the Home Office to investigate further. And it can start as a trigger when you have a pattern, because they can see that there's a pattern. But where you are innocent and you've got people who have just decided to leave, then you'll be fine. But it can be a flag for them to dig deeper. So if you do have people exiting genuinely, then just make sure that your house is in order in case it can trigger a visit or a suspension. So, Camera, there's a question about, is it a crime to employ a person for 20 hours and you don't have information about how many hours they do with their sponsor? So it's really important for you to document that you've done your right to work check, which will show you the employer that they're working for. You've done your safer recruitment. If you're working with vulnerable people, you've checked with their last employer, you've got references from them, and you've got perhaps a pay slip. Do your own due diligence, in the sense that if they're working for you for 20 hours, have you just made your calls to their current employer? And look at things like their location to you. So if you are based in Bournemouth and their principal employer is based in Scotland or up north in York, how are they doing those 20 hours? Are they coming down on a weekend and doing 2 days? You have to show that you have also thought about it. So you can be you can face a penalty. So it can be a penalty that you are employing someone who is working for you illegally. Because if they're not working for their sponsor, then they're not supposed to be they're in breach. The sponsor is in breach. And then the 20 hours that they do for you, it can be seen as that you have knowingly employed someone who is here being sponsored by another person, but they really are working for you. So think about things like random visits, or they can be working, even if you are the principal sponsor, but you've loaned them to somebody else and they're working in a different location. That's something which can cause the person who's employing them to get a fine for employing someone illegally. If they hold a sponsorship license, then that can also lead to them getting their license revoked if they get a penalty. So use your due diligence and check and record everything and ensure that you're covered. So your right to work checks are mandatory, and your references and how you recruit, make sure that you cover yourself. Our businesses are our livelihood, and you don't want to lose. If you're someone who's doing everything correctly, you don't want to have fines from the Home Office, which can bankrupt you. You don't want to be in a position like that. So do your own due diligence, record everything, and keep a record to protect yourself. And Flo Joseph has asked, if one did not put the commencement date on time, can you still put it? So you can retrospectively, you can do things retrospectively. So you can self-correct. You can self-correct. If there's something that you haven't done, you can still update it on your sponsorship management system. and you can do that. So you can change, you can notify the home office even if you have done it late, and explain why they started their work late. So that's something that you can do, and you can self-correct. Yeah. So with maternity pay, that is a really big challenge for organizations and for businesses, where someone comes in and they are already pregnant, and that's a question that is there. So that's something which I know is a challenge. So your employees are entitled to statutory maternity leave. So statutory maternity leave, it doesn't matter how long they've been with you, how many, or how much they pay, they are allowed to be on leave. But statutory maternity pay, so maternity leave, they can go on leave, but it doesn't have to be paid. So there's a difference. So for leave, anyone can go, but to qualify for maternity pay, they need to have worked for you as the employer continuously for at least 26 weeks, continuing into the qualifying week, the 15th week before the expected week of childbirth. So if they earn at least £123 a week, which most do, then they are eligible for statutory maternity pay. But if they've just arrived and they are pregnant and they've never worked for you, they can go on leave, which is not paid. And then when they've given birth and they're ready to come back to work, they can come back to work. What you have to do is update it on your sponsorship management system. So you have to go onto the system and update it to say this migrant is on maternity leave and they don't qualify for statutory maternity pay because they have only worked for me for 2 weeks. So you don't have to fire them, but they're not your financial responsibility. And so if they cannot work because they're too advanced, if they arrive and they're like 8 months pregnant or 7 months pregnant, then you have to do your own risk assessment. Your occupational health will have to see. Then you may have to ask them to go on leave, but it doesn't have to be paid. So again, those are things that are really important for you to get advice on if you find yourself in such a situation. Some employers have updated that, someone is on leave. They've offered them that it's better for you to go back and then you come back after you've given birth, because it prevents people falling into destitution, having problems. But most people don't want to do that. They don't want to then apply for the visa for the child. And these are some of the issues which then come up to cause problems for in terms of welfare. Because if they have no one to look after them, then it becomes a problem. So so that is something that's really important and a problem which many people have experienced. So thank you for all the questions. Yes. So I'm saying that you should be very careful in employing a staff who's sponsored by another employer and are not working for them. So because you are breaching the rules actually state that they can do 20 hours supplementary. So that's supplementary on condition that they are actually working for their principal sponsor. So they have to be additional hours. But if, for example, they are in between jobs, you have to check and make sure. But where they've never worked and they've come in and they're getting the 20 hours, this is what most people are doing. They're coming in with a sponsor who, not most people, but some people, a sponsor who is based in, like I said, in Leeds, in York. You're based in Bournemouth. They come in and they do the 20 hours. And some of it is actually community. People are helping each other because, people are really struggling. And so it's offering them work so they can survive and live. But when the Home Office comes and they ask you, have you done your checks? What have you done? So I've said to you that you need to make sure that you've done your right to work checks, you've communicated with the sponsor, you've written it on record, and you've also assessed their availability, the location of their employers. You have done your own assessment, because you will not be able to have a statutory defense if the Home Office come and do an inspection of your staff or check to say, how come this person has been working far, far away from their principal sponsor and they're working for you. So you have to do your checks, and it's important to do that. So this is something which has come to haunt people who felt they were doing good because they've had visits from the Home Office and the Home Office were not having it. So whenever in doubt as well, contact the business help desk. They're very helpful. You contact the business help desk and ask them, this is the situation. Am I compliant? And you will find they will tell you, but also read up the rules for yourself and interpret them. Because I'm not going to tell you anything, what you should do and what you shouldn't do, but I'm telling you what the law is. And I know the complexities of the situation that people in our communities are facing. And a lot of employers are, in my language, I'm from Zimbabwe, there's a saying about having mercy on people, and that sometimes you can end up getting yourself into trouble by being too kind and thinking that you're helping. So you can end up being the one, and people are not loyal, You can think you're helping, but you find you're digging yourself problems. So Sarah, you've asked about employing staff to work in children's homes, age 8 to 17 under the skilled worker visa. Under the skilled worker visa, yes. But under the health and care visa, there have been some employers who work in children's residential homes, which are regulated by Ofsted, where the Home Office has now started refusing using the code 6145 and 6146. And applications have been made using 6141 or using a different code. And I don't know if you've heard in the news when the Home Office announced the changes towards the end of last year. And one of the changes was that the health and care visa will be only for organizations who are regulated by CQC and not Ofsted. So there are changes in terms of children, particularly those services regulated by Ofsted. And so it's important to ensure that you meet the job specification and you're able to justify the salaries, etc. And I think one of the arguments that has been made is that it's not a shortage occupation, but there is a shortage in the sector. But it's a bone of contention, perhaps. So you would have to use a different code, and it may not fall into the health and care visa. So your staff would have to pay the immigration skills charge and a higher fee. So there is different decisions with different organizations, but also the Home Office scrutinizing, issuing COSs for that client group. So yeah, I hope that helps, Sarah. How do you rectify that someone lives in Scotland and you employed them in London? So if you've done it, yeah, I think it's difficult to rectify that one, isn't it? Because these are also, it's not someone, these are people who are doing 20 hours, so they're not on your list of people that you sponsor. So it's not on the sponsorship management system. So when you find out that a person is not working for the employer and you interview them and you make your checks, record it to cover yourself in case you ever have a visit. So it's important for you to record everything, but they're not on your system. So you can't rectify it on the sponsorship management system. But if you have a visit and you get a fine, then you need to seek advice about that. So I hope, that answers that question. Thank you. There's somebody who had asked about the SOC code for a care coordinator. I know it's 2 something. Let me just look for it. I'll look for it and share it later. It's so senior care workers are different, care coordinator. I think it's 2 something. I can't remember from the top of my head. But I will share it later. If you look on the website, so there's a really good website that you can use, which I'm going to put into the chat. And you can share, you can actually check for all the codes on there so that you make sure that you are you're putting in the right codes and checking through. I was going to just share it. I'll share it to meeting group chat there. So you can look on there, and the ONS digital, if you go onto there, you can then double check your occupation codes, and that's the coding tool that helps you to be able to access all the information. And the link to the Home Office manual, please read it and read it and read it and read it, because there's ignorance of the law is no excuse. So if you say I didn't know, it's not an excuse, because you have said that you are going to read it, and that is part of your duty. So as an authorized user, read it. As a director, just go through it yourself, make it your bedtime reading, and just make sure that you've read all 4 parts. There's part 1, part 2, part 3, part 4. So it's important for you to read. Yeah, so Stella, I've sent you the link on where to check out the code. And what if you want to promote someone from being a carer to a senior carer? So if you're promoting someone from being a carer to being a senior carer, so they're 6145, and you're changing them to 6146. So you need to interview them and show that you've gone through your own internal processes, offer them a new job, give them a new contract, assign a new COS, completely new certificate of sponsorship, and then apply for a new visa. So if the time that they are, if you're not changing the time that their visa expires, you don't have to pay an immigration skills charge. But if you are extending the time, then you may have to pay, you'd have to pay. But if you just, you have to issue a new certificate of sponsorship, new contract of employment, and update their actual visa so that they get a new visa. So you have to go through the whole process. Right. And when someone goes under the radar and evades all form of communication, you have to report that to the Home Office if they've been on unauthorized absence. So if they're on unauthorized absence, you've got 10 days within which from the time that they haven't come to work, then you have to notify the Home Office. You have to give them 10 days. So don't give months. I've seen people who are saying, I've tried to look for them, I'm phoning them, I'm trying everything. But where there's unauthorized absence, you do have to report it on the SMS system, and you have to stop sponsoring them. So you have to stop sponsoring them. You can't keep on just sponsoring them and think that you are being kind because you don't want their visa to be cancelled, but they've gone AWOL. So you have to notify the Home Office and you have to update your sponsorship management system. So reporting absences is very, very important. So if they have been absent from work without your permission for more than 10 consecutive working days, so 10 consecutive working days, you must report to the Home Office, even if you intend to continue sponsoring them. So you must make the report, if even if it's even if they're going to come back and you discipline them, you still have to make the report. And you must make the report by no later than 10 working days after the 10th day of absence. So, and that's in part 3 of your duties and compliance. So it's the information is all there. The Home Office expects you to read it and to familiarize yourself with it, and then make the reporting. So Yvonne, I think, who said that the carers are given the hours, but they tend to cancel every week. So that again is a disciplinary issue. It's a work issue. Why are they canceling? Why are they taking these unauthorized absences? Why are they never in work? So what would you do with someone who's not a migrant worker, who keeps canceling, who doesn't turn up to work? What is your disciplinary procedure within your organization? Have you implemented it? And what have you done? So that's what the Home Office would want. They would want you to demonstrate that you are managing your staff and you are applying UK employment law. So if an employer is taking the mickey and you have a business to run, you need staff and people are not working, or they're constantly telling you excuses, all different types of excuses, you've got to keep a record and go through the procedure, give written warnings, do a disciplinary. If it means that you have to let them go, then you have to let them go. But keeping them on your books will come back to bite you, only you, because it will be you who has not done your duty as a mini officer of the Home Office, because you're an officer of the Home Office. So so that is really important. Yeah. Yeah, no, I will definitely share a recording of this webinar, and we did limit this to 200. So there's some people who were not able to join, but we will share the recording. And I think it's the reason why we do this is it's so important to avoid people losing their licenses, because of the impact that it has, a ripple effect to the staff, to the businesses, and to then having imagine a big pool of people who are here in England without status. And the 90-day letters from last year, they've been coming through. It's difficult to find switches. People are reaching positions where they've got to go back and they've sold everything. It's causing a lot of mental health problems, a lot of depression, breakdown, suicide, because the thought of going back when you've invested so much in moving yourself and your family here, it's devastating for people. And it hurts. I find it so difficult to be advising people that you've got no option. If you don't find a switch, you have to go back. There is no legal option that I can tell you. There is nothing that I can say that you can do. And some people end up becoming living here illegally and being exploited even more. So it's a very difficult situation, and that's why we're doing this webinar, is to share that information so that we can stop. You do have to report disciplinary action on the SMN system. Yes, you do. And what if someone arrives and have a driving license but is unable to drive? That's another performance issue, isn't it? It's a performance issue, and it's something that perhaps you need to really make very clear But when people are not here, they'll tell you whatever you want to hear. So I don't know, in the recruitment process, it's maybe a reflective thing as to maybe your staff, before they come, you can get someone in the country of origin to test them. I don't know. But yeah, it's a difficult problem. If you need drivers and people are not driving, then it causes you a problem because they can't perform their duties effectively. So the Home Office will ask, did you make it clear? Did you check? What did you do? And then what support have you given them to be able to drive in the UK? Maybe send them, if they've got a license, they can do a quick course to familiarize themselves with the roads and driving in the UK, build up confidence. What support have you given them? So before you just say you're letting them go, they would, if they do decide to complain, but just from, just in the sense of what can you do, maybe try and see how as an employer you can support them and have that in your budget. So now, where will this recording be shared? I think we're about to finish. We will share it to your email addresses. And then we will share it to your email addresses. And I don't know how we're going to get your email addresses, but yeah, we will we will have to share them on our YouTube. I think what we can do is we can share this recording. We'll upload it onto our YouTube channel, and then if you follow our YouTube channel, you can then access it. Or if you download from our website the compliance checklist on our website. If you go onto our website, send us your details, we can send you the recording. I think that's probably the best thing to do. And Shez, yes, please give that carer a switch. I think that's really, really important. Give them a switch. If they're doing 20 hours and their sponsor doesn't have hours, please give them a switch. And you can also join our mailing list. I don't know if Tulia is still here. If you're still on the line, please share the link. I'm just sharing the link to our website. You can also just sign up to our mailing list. So if you drop your emails in the chat, we'll download the chat and then we will send you the recording. And also if you go onto our website, you'll be able to get that. Thank you. Somebody asked the last question that I'll answer. Someone said, if you ask the carer to stop coming within 28 days, then request them to return maybe in the second month. So what you should do is notify on the SMS system that they cannot come within the date and give them a new start date. So you would need to put a new start date on your sponsorship management system. I think I will do another webinar where we are demonstrating things on the sponsorship management system. I think that will be quite useful because it's important to know what to notify, what to update. It's also on the Home Office website. But if you are able to give a new start date and explain why they cannot come, that's really important. If you lose contracts, there's two more questions I'll answer about relatives and about the contracts. So if you lose contracts and you can no longer sustain, your business it's no longer viable for you to sustain the staffing levels that you have and the people that you've employed, then as a business, what would you ordinarily do? I know it's really it's difficult because of relationships, because of investment in people, and they've come from abroad. But if you cannot, I would always advise you to seek advice from if you've got an HR company that helps you, from ACAS even, and explain what's happened. And then you would have to go through the process where you have to make people redundant, unfortunately. So you would have to ensure that you go through the process, have the consultation, have the meetings, and go through the process and then let people go. And support them if you can to find switches, support them to move on so that they're able to then sustain themselves. But as a business, there is your business interest and then there's the interest of the individuals. Keeping them on a visa is maybe what you're feeling you have to do, but the longer you keep them on a visa and you cannot pay them, you are still legally and contractually obliged to pay them. So if they decide to take you to the tribunal for breach of contract and not paying their wages, they will win because you have a duty to pay them. As long as you are employing them, contractually, you are obliged to pay them. So whether or not you have hours, that's not their problem. Their problem is that they have a contract, you have undertaken to pay them, so you have a duty to pay them. So if you lose your contract and no one is paying you, then you have to do what you have to do, and perhaps support your staff to be able to find other employment. The Home Office is taking so that's that's one of the things. So yeah, and can you employ relatives? Yes, you can employ relatives. You can employ relatives, but what you cannot do, if you are the person who is the authorized user, the level 1 user, if you're the person who is assigning the certificate of sponsorship. So if you're the person who is assigning the certificate of sponsorship, you should not assign it to your relative. So what the sponsorship guidance says, it says that SMS users, so the person who assigns the certificate of sponsorship must not assign a COS to themselves or to a close relative or partner. And the close relative or partner is a spouse or civil partner, unmarried partner, parent, son, daughter, brother, stepbrother, half-brother, sister, stepsister, half-sister, nephew, niece, cousin, aunt, uncle, father-in-law, mother-in-law, brother-in-law. So there's a whole list there. And so but if someone else within your organization who is not related to your relative assigns the certificate of sponsorship, you then have to report it and put a sponsor note and disclose it to say that they are your relative and that they are related to anyone else. So you cannot assign it, but somebody else can, and you also have to make a note on the sponsor note, and also disclose it in your application, in the visa application when your relative is applying for a visa. So that's important. And if you haven't done it, yeah. Anyway, so that's one of the things. Yeah. So your company is assigning it, but if you are not the SMS, if you've got a staff member, then the staff member, who is your HR person, they can assign the certificate of sponsorship, but you do have to disclose it. So it's to avoid a situation in a company where your SMS, the person who's managing the system, is just giving all their relatives. They're not a director or anyone, but they are the ones who are busy just giving certificates of sponsorship to their relatives. And there's been no recruitment, there's nothing that has happened. So to protect the integrity of that system, somebody else has to do it so that there's a system of checks and balances, and then there is disclosure. So that's what's important. And even if the surnames are different, sometimes they just have a way of of finding out. I think it's better just to be honest. Just be honest and get somebody else. So or don't even employ your relatives. You find them a job somewhere else with someone else. It might even be better for you in the long term for other reasons as well. So I hope that is oh dear. So yeah. So I think that that's all for today. And if I'm oh, sorry. I think you did put this message up. If you're going to demote a senior carer to a carer, it's the same way as promotion. So you just have to record why you are demoting them, what has happened for you to demote them, give them a new contract, inform them, and then give them a new certificate of sponsorship with the right code. And the pay, if it's going to be reduced, you have to notify, you have to make sure that you update that, change their contracts, get them to sign the contracts, and then update their visa as well. So it's the same process, but the opposite way. Right. So yeah, that's great. I think that's all for today. Thank